So, hello and welcome, everyone. Today, we are going to take a look at a decision from Germany, a decision of the Higher District Court of Munich in a dispute between VoiceAge as the claimant in these proceedings and HMD as the defendant. This is a very interesting decision because it's, on the one hand, a decision that has been delivered by a higher court in Germany, so a higher district court. So in itself, it has a little bit more weight than decisions of the district courts. But it's also very interesting because we had something that does not happen very often, especially in Europe and in Germany. We had an intervention of the European Commission in these proceedings, where the Commission provided some input or some views about how to interpret and how to apply European law, in this case here. And we had the court providing guidance on that or answering to the Commission. So the decision, at least a part of the decision, is dealing with very fundamental questions regarding how a front defense should be treated in proceedings, and how the parties' obligations should be seen and interpreted. And that's why it has a specific value here. It is also very interesting because compared to the existing status quo and the case law in Germany, the court provided some more nuances here regarding specific aspects. And as we're going to see later on, particularly one aspect, which is the security payment that the implementer should provide when it comes to front and SEPs. And here the court, let's say, expanded the jurisdiction or added some further aspects in the jurisdiction, and also the case law of the German courts so far. So this brief introduction, let's take a look at the facts of the case here, as we always do. The first contact between the parties was back in August 2019. VoiceAge sent a notification letter to HMD. We're talking here about patents that are essential to the EVS standard. Then there was no response and no agreement to these notifications. And some months later, in October 2019, the lawsuit followed. VoiceAge filed the lawsuit against HMD in Munich, and shortly after that also made a licensing offer. What is interesting to keep in mind here is that this action, as it was filed, when it was filed initially, it was only looking at a declaratory judgment for damages and also for the provision of information and rendering of accounts, meaning that initially there were no claims for injunction or a claim for the recall and destruction of infringing products from the market. This, as we're going to see in a moment, was added later on. Now, after having received the lawsuit and having also received the license offer, HMD responded, made a statement there saying that they would be basically willing to take a license, however, under conditions, specifically that the patents are valid, actually essential and enforceable. This was done in November 2019, and some months later, HMD also made a counteroffer, which was, however, not accepted. Then in February 2021, the thing that I mentioned before happened. VoiceAge expanded the lawsuit and added also claims for injunctive relief and other exclusionary measures. So just for us to keep in mind, an injunction was in play in these proceedings almost 14 months after this case started. Then the proceedings moved on this basis, so including the claims for injunctive relief. And in May 2022, the decision of first instance was delivered. The Munich District Court found in favor of VoiceAge in these proceedings and granted an injunction against HMD, among with other remedies. This led then HMD to appeal the decision. And then we ended up in these proceedings we're discussing today before the Higher District Court of Munich. Almost 2 years in these proceedings, then we had this intervention of the European Commission I mentioned before. The Commission filed an amicus curiae brief in the appeal proceedings, saying basically that it has a specific view of how to deal with issues that had been discussed also in the first instance by the Munich District Court, particularly how to look at the obligations of the parties under the Huawei ZTE framework of the Court of Justice of the EU, and suggesting more or less that these proceedings should be stayed in order to give the Court of Justice of the EU the opportunity again to provide guidance on this framework, on the Huawei ZTE framework. Now, the court heard these arguments and had also the Commission participating in oral hearings before the court. And in October last year, it provided a preliminary opinion giving its views on all of these topics and also, in a sense, responding to the Commission. And here, generally, the court did not, let's say, move away very much from the line of German case law so far, and in several aspects was not very much convinced by the Commission's views. So this was, let's say, an interim opinion of the court, giving the parties and the Commission opportunity to position themselves again based on this view of the court, so that the proceedings after that went on. So they had this preliminary opinion, the court gave its view, but the proceedings went on. A couple of months later, then HMD provided a bank guarantee. This was, in a sense, a security payment for the claims that have been asserted here. We're going to see in a moment that this was also discussed by the court, because, as we said already, the court placed a lot of focus on the security and the provision of security here. But at the end of the day, this payment did not change much in the decision of the court, because with the judgment from March 2024, the Munich High District Court dismissed HMD's appeal. What the court did, however, was that it allowed an appeal to the Federal Court of Justice in Germany, which is the highest court in Germany. And as far as we could see from media, it seems that HMD actually filed this appeal. So it can very well be that this case is going to be discussed also by the Federal Court of Justice in Germany, which could turn out to be the second time in which the Federal Court of Justice will weigh in front cases. We're going to wait and see, of course, however, how this evolves. But there is a good possibility that these proceedings are going to go a step further. Now let's take a look at the reasoning of the court here. As I said in the beginning, given that we had also this intervention by the Commission in this case, the court provided some input on some fundamental issues when it comes to the front defense. And for example, what is the context in which the front defense is being raised? What is the actual content of the defense, and what would be the result of a successful front defense? And then, having said that, the court moved on to be more specific, looking at the Huawei ZTE framework. So we're going to start also from this more general aspects that the court raised here, because I think they are very important if you want to understand the reasoning of the court later on, the more specific input of the court regarding the specific case here. Now, looking at the front defense, the court said which is the context in which the front defense is being raised. So we have to deal with the front defense when we have already found infringement in proceedings, which means that the front defense is basically a defensive plea in law of a party that is using the patent without permission and continues using the patent without permission, which means that generally what you should try to make sure is that the patent owner remains able to procedurally enforce the patent and particularly enforce the cease and desist claim. Because if you have the situation where you have already infringement and the infringement continues, basically the court said referring the patent owner to claims for compensation for past infringement is not sufficient. Now, of course, when you have an SEP or a front committed patent, there are some differences. The court noted here that the patent owner that is obliged under competition law to allow use by a willing licensee of its patent can enforce its exclusive right only if it's itself willing to offer a front license. This goes back also to the Huawei ZTE judgment and their requirements to make a front licensing offer. Then the court said whether there is such willingness on the side of the patent owner. If you want to examine that, what you need to do is to comprehensively assess a concrete license offer of the patent owner. And then the court said this is, of course, something which is not the most easy thing to do. An assessment, a comprehensive assessment of a license offer is usually very time consuming and often requires involvement of experts. And in this context, you should take into account that the patent owner must nevertheless, although this is something that will take time and will need to also expert opinions, it should remain in a position to fend off infringement effectively and swiftly. So it doesn't change basically in the process, in the proceedings, that there is a need to make sure that the patent owner can stop infringement in an effective and swift manner. That meant in the eyes of the court here that the front defense, when it's treated in the proceedings, it should not factually curtail the patent owner's legal position, because the court said what the front defense is a corrective against an abusive conduct in antitrust terms. So the court tried to strike a balance here by saying, of course, you will need to examine the front defense if it's raised, but on the other hand, you should not examine the front defense in a manner which would basically curtail the legal rights and the legal position of the patent owner, especially the right to have to stop infringement, because what the front defense is just trying to correct behaviors that are violating antitrust law. So you should try to find a balance there, and we're going to see later on that the court that this notion, this general notion, was repeatedly coming out in the court's thinking. Then the court looked at the nature of the front defense. So what is the argument basically that you're bringing there? And this is also important because the nature also dictates in a way what are the consequences if the defense is successful. And the court said that the front defense, in essence, is a so-called dolo agit defense. So what does this mean? This is a Latin term which incorporates a principle of civil law which is very generally used and very generally applicable. And in core, it means that you should not order a party to do something, to perform something, which one legal minute later, if we want to put it in simple words, it will be in a position to claim back. And this is what happens here, because you have on the one hand the patent owner that has a claim to have an injunction or imposed, so to stop the use. But on the other hand, you have the defendant asserting with the front defense a claim against the patent owner to be granted a license, so to be able to use the patent under specific conditions. And this is how the court looks at the front defense at the end of the day. So as a dolo agit defense, meaning that it is basically a defense saying that I shouldn't be condemned to stop using a patent, because at the same time, one moment later, basically, I have a claim to use the patent. And this has an impact of how the court is going to decide if the front defense is successful. because then regularly the court would dismiss the defense as currently unfounded and not as inadmissible due to an abuse of legal rights. And this has several implications. I think maybe the most interesting one is that if a defense is successful and the action is dismissed as currently unfounded, as the court said here, this means that the action can basically be filed again because you can remove any obstacles and you can assert the same claim later on. Whereas if it's inadmissible, it might be a bit different. So this was here also the court giving its view of how this defense functions and what is its impact is in the proceedings. And then the court turned to the Huawei ZTE framework. And here the court dealt a lot with the amicus curiae brief of the Commission, because the Commission had taken a very strict view, let's say, of how to look at the Huawei framework and how to interpret it and also how to apply it practically in trial by focusing very much on this steps approach. So saying that there are the Huawei ZTE judgment has set up mutual conduct obligations in forms of steps, which need to be performed one after the other, which means also that if one step is not met, the examination ends there. So you have to draw the consequences of this specific step not being fulfilled, not being met, without the need to look at the whole story of negotiations in a more comprehensive, a more overall manner. And this was a very big discussion here, whether this view of the Commission, this more strict approach of the Commission, is the one to be applied by the courts when they deal with front cases. Generally, the German case law after the Sisvel higher decisions of the Federal Court of Justice in 2022 had interpreted the Huawei ZTE framework in a more flexible manner. So here it was basically this question whether you should follow this more strict approach of the Commission or whether you should stay more in line with the more flexible approach that the German courts have laid down in the last 2 or 3 years. The Munich court basically chose to stay very much in line with the case law of the German courts so far and did not follow much the Commission's opinions or positions here. It said generally these steps that are laid down in the Huawei ZTE shall generally be followed, of course. However, the court said a strict compliance with these steps shall be no end in itself, forcing parties into a confining corset in negotiations. So the court here accepted that the Huawei ZTE framework has laid down a more dynamic negotiation concept. In the proceedings, particularly, this means that there is also not a strict order of these steps. This means that the court is not required to examine its steps one after the other, ignoring what happened after its step was taken. So this very, let's say, formalistic approach of the Commission that you should examine the steps in an isolated way and then stop the examination or stop the assessment of the parties' behavior when one step has not been met, etc., was not really followed by the court here. On the contrary, the court said what you need to consider is the rationale and the objective behind its step. So it could be that if the goal of its step has been fulfilled at some point during the negotiations of the parties, that you should not look back very much whether the form has been met. So if, for example, information has been provided that should have been provided under a notification of infringement during the course of the negotiations, you should not really look at the formal requirements of an infringement notification. We're going to take a look at that in a moment, more in detail. But what the court also said here, and we're going to see this was very much important in its decision later on, is that this issue with insisting on formal flaws of this conduct obligations, and trying in trial later on to base your case on purely formal flaws of these steps is maybe not is something that is should be provided to the parties, especially if they moved on and after this maybe not perfect step was taken, they engaged in negotiations. So here again, the view that you should not really look at this HMD framework from a very formalistic perspective. This also means, and here the court disagreed again with the Commission in the amicus curiae brief, that a failure to meet a step does not automatically impact the prospect of success of the front defense. And this goes either way, meaning that if, for example, the patent owner failed to meet a step, this does not mean that you will not look at anything else and grant the front defense. But also, on the other hand, if the implementer, for example, was not having a formally valid willingness indication, this does not mean that you're going to stop the examination as a court and grant an injunction and dismiss the front defense. So here again, the court looked at this more flexible approach on this whole HMD framework. And it said so by saying that this is not something that you can extract from the HMD case. So in contrast to what the Commission believed, the court did not see the HMD framework limited to the mere execution of steps and formalistic declarations with no aim at reaching a negotiated agreement. This is a view which the court dismissed here. And it also pointed out that even in the amicus curiae brief, the Commission was not really consistent in its pleading so far. So generally, this formalistic approach was not accepted by the court, and the court remained much more into this more flexible approach that German courts have taken so far by looking more in a more holistic, more comprehensive way into the parties' negotiations and conduct before and also during the proceedings. So now we've seen the court's more general thoughts about how the front defense works in proceedings and how the HMD framework is going to be interpreted. And now let's take a look at the more specific feedback of the court regarding the specific case here and the front defense that HMD had raised. Before going into the details of the parties' behavior and the duties, there was a very brief, however interesting, some thoughts of the court regarding whether VoiceAge had a market dominant position here. This is a step, of course, the very first step to examine when you have a front defense in German proceedings, which predominantly focus on an antitrust perspective, because, of course, the main argument is that the filing the action was an abuse of a market dominant position, and an abuse of a market dominant position requires, of course, that there is a market dominant position of the patent owner. In the end, the court did not say here whether VoiceAge had a market dominant position or not, because it found that the front defense should fail here very obviously for another reason, especially for the fact that HMD did not provide proper security. But it made a couple of remarks which are interesting if you want to look at this issue. The court expressed some doubt whether there is a market dominance here, basically for two reasons which were pleaded by HMD itself. The first one being that they managed to make a workaround regarding the patent in suit here. And the second one that they managed to also sell products in Germany, especially at the latest after February 2022, which do not use the EVS standard at all. And of course, the court said here, if this is true, then you can ask yourself whether there is a market dominant position if the implementer is in a position to bring products in the market which do not use the patent at all or do not use the relevant standard at all. So here, some interesting thoughts of the court of how to approach this issue of market dominance. Nevertheless, the focus was more on the actual conduct obligation. And here, the court started with the notification of infringement, which is under Huawei ZTE, the very first step that needs to be taken by the patent owner. So you need to inform the implementer that there is a patent infringed and there is the need to take a license. And here there was some discussion also in the first instance about whether the letters that had been sent by VoiceAge had been sufficient or not, whether they contained all necessary information or not. This was one point that the court did not really examine here, because it said the sufficient notification of infringement was done by the lawsuit filed, by the action that was filed. And if you remember, here we had the specificality that that the action initially did not include claim for injunctive relief. It was focusing on damages and provision of information, rendering of accounts, etc. So the court basically said, if you look at the goal of this obligation to make a notification of infringement is to provide information about the patent, about the standard, etc. This has been all fulfilled with the action that was filed. And since the claims for injunction came almost 40 months after this action was filed, this information was also there before you had actually claims for injunctive relief asserted in the proceedings. So in the eyes of the court, this was sufficient. So the information provided through the action was seen as a sufficient notification. Then, however, the court said, irrespective of that, here in the present case and in the present stage of the proceedings, HMD would not anyway had been in a position to invoke flaws with the infringement notification. And why is that? Because HMD had signed an NDA, had exchanged offers with HMD before the lawsuit was expanded to include injunctive relief. So it would be here, in the eyes of the court, an act of bad faith to raise purely formal flaws of the notification at an early stage of the negotiations of the parties, after having engaged in discussions. So here the argument was basically to say, well, you cannot really say a long time after you have signed an NDA, you have exchanged offers, you have exchanged information, you have discussed about a license, you cannot come back in trial years later and say the initial notification, however, had some flaws. It was not formally perfect. And we're going to see that this is a very fundamental notion which the court used later on also in with regard to the willingness, for example. This does not mean, however, that the implementer will not be able to raise any concerns regarding the provision of information before the lawsuit was filed at all. So the court gave some examples here when this would be admissible. For example, if the lawsuit was filed without any previous notification, or there was a notification before the lawsuit was filed, but it was not indicating which patent is infringed. And an additional scenario where you could anyhow raise related concerns in trial is if you would file a lawsuit and file it very shortly after you have provided a notification of infringement, even if the notification of infringement was proper and adequate. There you could raise some concerns whether this was enough or not. The court particularly mentioned here an example when you would have made the notification and you would file the action the day after. So this was on the notification of infringement. Then the court turned to the second step, the willingness to obtain a license. Here again, there was some discussion, especially also in the first instance, about whether this response of HMD, which, if you remember, we said they said we will be basically willing to take a license under conditions, and the condition was that the patent should be valid, actually essential, and enforceable, whether this was a sufficient notification or not. So the parties had argued for and against that. But again, the court said here, in the present case, as the things evolved and in the present stage where we are now, VoiceAge cannot invoke any lack of willingness on HMD's side because this would be a breach of good faith. Again, the reason for that was that VoiceAge had engaged in negotiations, made offer, made another offer, then received the counter offer, etc. So generally, the court said if the patent owner has engaged in negotiations, made an offer, despite the fact that there was a missing or a sufficient declaration of willingness, might have problems coming later on in the proceedings and arguing that the implementer was nevertheless unwilling. So again, here the view on how things evolved and how after this very moment of the notification, the willingness declaration, how things evolved here also played a role. And if, despite the lack of willingness on the implementer side, the patent owner engaged in negotiations, it might be hard then to argue later on that the patent owner had been unwilling. Very similar to what we have seen with the notification of infringement, however, on the other side of the table now. Then the court turned to the patent owner's offer, and here I think the court laid down some of the core ideas of how to deal with the front defense in proceedings by basically identifying two different scenarios that might happen with the offer of the patent owner. So the one scenario is that the offer is front, and the other scenario is that the offer is not front. And depending on each of these scenarios, the court looked at different consequences and also supported the different treatment of the front defense in proceedings. Looking at the first scenario, so the court said if the patent owner's offer is front, what does this mean for the front defense? The front defense is going to be dismissed in the eyes of the court in this case. Why? Because if the offer is front, the only admissible reaction of the implementer is to accept the offer. It's not to make a counter offer. If the offer of the patent owner is front, you must accept the offer. So this is the only thing that's reasonable and the only thing that's admissible in the eyes of the court. Because the implementer in the eyes of the court must accept an offer which is within the front range, even if the offer is only just front. So if it's within the front range, it must be accepted because the implementer has no claim to request license terms at the most favorable end of the front range for him. So the first scenario, if the offer is front, then basically there is no room for the front defense. The front defense is going to be dismissed irrespective of what the implementer has done afterwards, because in principle, a front offer of the patent owner must be accepted by the implementer. Now, what happens in the second scenario if the offer is not front? Does this mean that the front defense will be granted? This is more the view of the Commission. But the court said here, no, this is not the case. This is not automatically the case. So if the offer is not front, especially the first offer of the patent owner is not front, this triggers the obligation of the implementer to make a counter offer and eventually also provide security if the counter offer is rejected. So the court said here, in principle, the implementer's duty to make a counter offer is relevant only and just when the patent owner's offer is not front. So if you have an offer by the patent owner and it's not front, this does not mean you have a successful front defense. This means, in principle, that you have to have a counter offer by the implementer. And this is where the court turned then to look at this part, so the implementer's duty to make a counter offer. And it made clear that this will be regularly required. So if there is an offer there is regularly a duty to make a counteroffer. There might be some exceptions based here also on the Sisvel higher case law when the offer is absolutely or evidently unfront. But in general terms, when the patent owner makes an offer, even if the offer is unfront, or specifically when the offer is unfront, the implementer must react to that and make an offer, a counter offer, and provide security if that counter offer is rejected. What is the consequence if the implementer does not do that? The court said if these reaction duties, which include the duty to make a counter offer and to provide security, they are not met. If these are not met, then the front defense will be dismissed. And the further consequence of that in the proceedings themselves is that since the action will be dismissed if there is no counteroffer and there is no security payment, the court must first examine whether these requirements have been met before looking at the offer of the patent owner. So here the court clarified that in trial, the counteroffer of the implementer and the security payment will be examined before the court will look at the offer of the patent owner. This means that for the court to start examining or enter into the examination of the patent owner's offer, you will need to have a counteroffer and you will need to have also an adequate security payment. Otherwise, the court is not going to go into this examination. Now, what does this mean for the counteroffer? Does this mean that the court is going to examine the counteroffer in all detail to see if the counteroffer was front? The court took an interesting position here by saying that this is not something that should happen in the infringement proceedings. So whether the counteroffer was front or not is not relevant in the infringement trial. And it gave two reasons for that. Because if the offer of the patent owner before has been front, then the counteroffer is irrelevant. Because it's the offer of the patent owner that the implementer must accept. So what he has counteroffered is irrelevant in this scenario. But even if the offer of the patent owner was not front, then if you want to make an assessment under competition law and look if there is an abusive behavior, you have to focus again on the offer of the patent owner. So this is what you need to look at, whether the offer was front, the first offer, or whether the offer has been improved to become front. But what the implementer counter-offered is again not relevant for this assessment. So the question, of course, that's posed here is the counter-offer totally irrelevant? The court said no, it has a function, especially in the negotiations, where providing input gives you the opportunity as an implementer to express substantiated concerns against the offer, and this in turn gives the patent owner the opportunity to optimize and adapt this offer. So this means that the counteroffer itself, as it's stipulated in Huawei ZTE, is not really irrelevant in a sense that it can be very helpful and it can have a very important role in the negotiations. But in the proceedings themselves, the court said here that the courts do not need to examine that. They will just need to check whether counteroffer has been made and whether it's accepted, but not go into the details and look at the counteroffer's front conformity, because this question at the end of the day, if it was front or it wasn't front, is not relevant for the assessment of the front defense. Then, having said that, the court moved to the last, let's say, step of the Huawei judgment, which is the security payment. And this is a part of the Huawei ZTE judgment where we haven't seen a lot of case law so far, that it has not really has been addressed much by the court, because usually the court did not come into this into examining this phase. But here in these proceedings, the security payment got a very key role, because the court, as we're going to see in a moment, had placed a lot of weight on the security payment and whether adequate and sufficient appropriate security payment has been placed by the implementer. Now, generally, of course, the court said we have this obligation under Huawei ZTE to provide appropriate security in accordance with recognized commercial practices. So this is the duty. If you want to look at now more into the detail, what does this mean? The court said these recognized commercial practices are not given. They were not given when the Huawei ZTE judgment was delivered by the CJEU, and since then you didn't really see much being established in the market or in real life, because also in the case law, because as I mentioned already, there was not much discussion in the cases about this step. So what the court should focus now is to determine what is the appropriate security. And here there were two elements. The first one is the very obvious one. So what is the right amount to be paid? And here the court said appropriate is to calculate the security based on the patent owner's last offer. So not on the counter offer that the implementer might have made, but the security payment must be calculated based on the patent owner's last offer. The reason for that was what we mentioned already before, that from a competition law perspective, on which the front defense is based here, it is only about what the patent owner does. If its offer is front, if its offer is not front. So this is the only thing that matters. So also, if you want to basically avoid an injunction, this is also the threshold that you need to take. So only the patent owner's offer is relevant. So that's why the last offer should be also the basis for the calculation of the royalty. There was the question here, should it be on a global basis? Because if you have an offer by the patent owner, which is global, and you are before German courts being sued based on a German patent, you could have the question whether you should basically limit the amount only to the German patents or maybe uses in Germany. But the court said here it must mirror the fee for a global portfolio license. Because offering a global license is, as a rule, front. And what you need to consider also, according to the court, is that the security does not refer to damage claims, but it tries to secure the licensing fees. So it's a bit different, and it should be also on a global basis, based again on the last offer of the patent owner. Now, that the court linked that requirement also to the issue of willingness, because it said providing security is a concretization of the patent user's willingness to license. And again, you can show this willingness only by providing a security corresponding to the respective amount of the patent owner's offer. So here, very clear view of the court that when it comes to security, it's not what the implementer believes is right, but it's more than what the patent owner suggests it's right. That should be the basis for the calculation of the fees. Now, there was here a counter argument to say, well, this can create problems, however, because it might give an incentive to patent owners to make grossly inflated offers, because then if you would need to provide security in order to be able to argue your front defense at all in the proceedings based on the inflated counter offer of the patent owner, that might be difficult. But the court saw here not a real issue, because on the one hand it said it's in the interest of patent owners, even when they sue, to sign a license. They don't really care so much about permanently enforcing an injunction. And on the other hand, if you would make a very high offer, there is a high risk that this offer is not going to be found to be front in the proceedings, which would have the action dismissed lately, and this would be the case despite patent infringement. So this was the court's first point, which is about the amount of the security payment. And then the court added here an element which was not there before. The court said that the security payment should also be qualified. What does this mean? This means that apart from, let's say, placing the money in an escrow account or providing a bank guarantee, the implementer must make a binding declaration that the patent owner will receive the security amount if the patent owner's offer proves to be fraud and there is a final decision confirming the infringement. So this is relatively new because we haven't seen that in this form before, and the court also recognized itself that this is not explicitly mentioned in Huawei ZTE, but the court derived this from the requirement to make an appropriate security, because it said if there is no such commitment on the side of the implementer, that if the court finds in favor of the patent owner at the end, it also must get this money that is being placed as security. You have a potential to have delaying tactics here. So especially providing the security amount, then waiting for the court to examine the offer of the patent owner. This might take some time. And then if you reach a stage where it's clear that the court tends to find the offer to be fraud, then you can basically withdraw your front defense, take your security amount back, and ask the patent owner to get his money back through damage claims, which the court found to be weaker here. So the court found this commitment, although it's not explicitly mentioned in Huawei ZTE, is part of the appropriate security, because the function that the security payments should do should not be able to be overcome by basically withdrawing the front defense at a later point in time in the proceedings. Interestingly, this view here has spread already, and the UPC in the Huawei versus Netgear decision has adopted a very similar approach regarding the security payment. So the need also to have this qualified security payment. So having said that, the court reached this conclusion here. So you're going to, if there is an offer by the patent owner, you will look at the counter offer. If this counter offer is rejected, you will need to look whether there had been security provided, qualified security provided, and then based on the answer, you have also your answer regarding the front defense. So if there is qualified security, this means the court will move on to examine patent owner's offer. If there is no qualified security provided, then the front defense will be dismissed without examining the patent owner's offer. And in the present case, the court clearly saw that Huawei HMD did not provide a qualified security and appropriate security under Huawei ZTE, because the final security amount with the bank guarantee was calculated based on the counter offer of HMD. And of course, this additional element, this commitment, was not given here. So that was the main reason why the court dismissed the front defense. So that was all with the front defense, which was the main part of the proceedings. I just wanted to mention also one final point here, which was the issue of proportionality, which was raised in these proceedings as well, basically arguing that it would be disproportionate to grant an injunction here because the harm that HMD would suffer would be disproportionate compared to the value or the value of the technology or that the patent incorporates here. So the court did not accept this defense here, that you should limit proportionality, limit an injunction or exclude an injunction based on proportionality, because basically the argument was that there could not be a real harm based on HMD's own statements, because as I said already, they had claimed that there was a workaround which allows them to selling products in Germany without using the EVS standard. And there was also no sufficient pleadings that non-EVS compliant products are giving losses to HMD. But apart from that, more generally, the court said here that when you have standard essential patents, proportionality generally does not come into question. Why? Because you have, as an implementer, a claim to be licensed on front terms. And if you don't meet your duties and you don't accept particularly an offer of the patent owner that's front, then you should not have the possibility on top of the front defense or to be adding proportionality defense, because this would give you basically an opportunity to circumvent your obligation. And this is something that the court found is not justified here and is not reasonable. So again, maybe interesting to take away that the High District Court of Munich, like the district courts in Munich, but also elsewhere in Germany, seem to be very cautious generally to apply proportionality considerations when you have SEPs asserted and front committed patents and there is a front defense available in principle.